Yes, Mr Brown.
I'm grateful. I said I'd start on the substance of the grounds now after the short adjournment. There is one point I'm going to take out from them up front, and that's just to look very briefly, make some observations about the architecture of the Heller document. It's at supplementary bundle 2, but I think I can do this largely from the judgment for now, because I really am going to make some high-level observations. I'm not going to go through and fish out particular words and points of detail here, but it's the shape and the structure that I seek to emphasise. And so I propose, before I get to the grounds in a minute, to flick through it relatively quickly. The reason for doing this now is that a few of my learned friends' grounds comprise points of detail about whether an idea expressed in one part of the text or a diagram on one page can or cannot realistically be read together with another, or in light of another idea expressed on some other page. The judge, of course, had to approach the document as the whole because the skilled person is deemed to read the cited prior art as a whole, and to do so with interest. And his interest, unlike that of a patent lawyer, can be relied on not to die out before he gets to the end. So before we go to the grounds, and as so often is the way on an appeal, zoom in on particular figures and lines that are relevant, in my submission it does pay to review the architecture from 33,000 feet first. So I can take this, as I said, from where the judge dealt with the disclosure of Heller, which is at paragraph 203 and following. That's on page 116 of the core bundle, behind tab 6. So he makes some preliminary observations about what the document is and its and the configurations it describes in 203 to 205, and then discusses the summary of the invention at 206, and a little about paragraph 10, about the insertion of the sensor at 207. Then at 208 we get a series of definitions in the patent, in the Heller document at paragraph 60. And the judge notes there's a lot of detail about various forms, and I emphasise that, of sensor from 77 to 197 by reference to figures 2 to 10. So this is all within the main configuration, but there are various forms of sensor, for example, described. By way of example is the one in figure 2, which shows the sensor 42, and the judge talks about it and goes through the diagrams that my learned friend helpfully took me through earlier on today. Then at 209 comes the insertion device, the next bit of this overall apparatus, which is described in the paragraphs from 201 to 211 by reference to the figures 12 and 13a to c, and again it illustrates various forms of insertion device. It explains, as the judge says in the last words of page 117, a carrier on the insertion gun drives the sensor and optionally the insertion device into the skin of the patient using a force of various means, which may be manual or mechanical, including a spring or a burst of compressed gas. So again, there's a whole bunch of options. Next, 210. The next section concerns the on-skin sensor control unit, and again, it involves discussion of a number of different figures, because there are a number of different options. At 213, the judge says, the specification discloses various embodiments or arrangements of the sensor control unit in which a number of options are considered. And then at 216, he gets to the description in paragraphs 229 and 230 of Heller, describing the alternative embodiment. This is the integrated embodiment that corresponds with figure 32 of Heller. So the central point that I wanted to get from this, and this is unashamedly an abbreviated review whizzing through the document very deliberately, this is not a patent specification of the sort that one sometimes sees, where one's delivered the concepts in the invention up front after a bit of background, and then just an illustration by reference to one or two singular, complete embodiments, with all the choices made in them. Instead, after the more general background material here, the summary and the defined terms, the detailed description takes the invention a bit at a time and explains a whole series of options for each of those bits, one after the other. So it's inherent in my submission in the way this document is arranged, the way that the Heller patentees have chosen to teach their reader, that in implementing what he or she is taught by this document, the skilled reader will understand the need to mix and match different options from the menu in respect of each of the different aspects of the invention. Certainly, there can be no error in my submission in the judge having taken an approach to this document that fairly reflects the way it's arranged and written, where it's inherent in the way that this is disclosed that one has to do some mixing and matching to produce a complete device.
Well, you say it's an a la carte menu and you pick a starter, a main course and a dessert.
Yes, indeed. There aren't two tasting menus with no choices to be made, which is what one might get in a patent specification, and one does sometimes see that. The cooking of the kitchen will be illustrated by reference to these two menus from a year ago. That's not it here. It's a la carte for every particular bit. So the reader knows that they've got to mix and match bits of the disclosure of this document in order to produce a complete unit. That, of course, isn't all I have to say about Heller, various parts of which, many of which you've seen already, we'll return to under a couple of the grounds.
But you say that Heller is providing a menu of parts for an integrated assembly, do you?
Certainly, yes. So a menu of parts that could be used for an integrated assembly,
Yeah.
Absolutely. Yes. What I say is that there's no basis in the document, and the judge can't be said to have been in error for not taking an approach whereby you say, oh, but this wasn't connected to that in the particular example in figure X. Because it's in the nature of this document that you've got to make a choice in respect of each of the various bits and pieces you're putting together to produce a device. So a submission that starts and ends with, oh, but it wasn't connected to that in this one, is difficult to get off the ground without more in my submission. That's all I wanted to say by way of preliminary observation. So ground one first. I said I would take a little longer over this than the others. I say that so that you don't get frightened. This is how long I propose to take with all of them. The judge dealt with this aspect of the obviousness case at paragraphs 203 to 230. That's the disclosure of Heller section we just looked at. And then 335 to 392. Starts on bundle page 144, the obviousness over Heller section. My Lord Justice Lewison put a question to my learned friend this morning about 336. And that last sentence in particular, on Dexcom's case, no substantial changes were required, which meant there was ample motivation for the skill team to take Heller forward. It was suggested, I think, that this was perhaps looking through the wrong end of the telescope, because it almost suggested the motivation was being sought in the patent. There are 2 points I would make about it shortly. First, as I understand this paragraph, the judge is recording Dexcom's case. He's not making a finding as to the approach he is taking. Second, as a matter of reality, of course, one is comparing with the patent and the Pot-Soley analysis, for example, has that inherent in it. We're asking ourselves, what are the difference between what's in the claim? We ask ourselves, what's in the claim, what's in the prior art, and what's the difference between, informally speaking? So I said there wouldn't be any great vice in taking this sort of approach, but as it is, this is just a recording of what Dexcom said rather than the judge's statement of what he's going to do. During the course of dealing with ground one, I'm going to deal with my Lord Justice Arnold's questions on the alternative starting points. I should be able to do that relatively briefly because it sounds like my learned friend and I are in more or less the same place on it, but I'll do it towards the end of my submissions on this ground. So the essence of this ground is that Abbott contends the judge chose a so-called hybrid starting point in Heller, finding the claimed invention obvious, when he essentially preferred Dexcom's case over Abbott's. And Abbott say he adopted as that starting point a mixture of features from figures 32 and 33, as my lords have heard, and that such a combination was impermissible in principle. Now, first, I observe that there isn't, in principle, anything wrong with taking a so-called hybrid starting point in a single prior art reference. There's no particular need for either the skilled person or indeed the judge to chart a linear course through a document to arrive at an assessment of obviousness. The judge has to appraise the disclosure as a whole, as I've emphasised, hear and consider the evidence about it, and then reach a global in-the-round view, and that's what he did. And I say that submission's fortified by the submission I've made already about the structure of Heller. That it was starting from a document that presents a mix and match menu. Indeed, Abbott didn't cite any authority as a basis for saying that a hybrid starting point in a single document is a problem. Their only authority cited on this ground is the Technograph case, but that's different. It goes to the effect that one must be careful to avoid the hindsight that can creep in if one salami slices an invention and tries to treat it as a series of micro steps, each of which might be able to sound obvious, but the combination of which might not be. That case just doesn't get them to saying that it's impermissible for a skilled person to put together different insights from within the same document, the whole of which he or she has read with interest. This isn't on any view a case of mosaicing from different documents. The judge has based his analysis entirely in Heller, and you have my submissions about the structure of it. At paragraph 204, which is where we were just looking, the judge was considering the disclosure of Heller, he explained there that there were two configurations of analyte monitoring system, referred to respectively as the main configuration at trial, referred to, and the figure 32 configuration. Abbott in its skeleton alights on the judge's words in that paragraph where he describes Dexcom's case as one that involved deciding to take forward something of a combination of the two. He acknowledged there that Abbott had said the two sets of teaching were incompatible. Abbott's real problem is simply that the judge didn't agree with that submission. It's not that he failed to consider it. So back to the assessment of obviousness, which starts on page 144, paragraph 335. In the first paragraphs there, between 336 and 341, the judge outlined the parties' respective cases on obviousness, so he did take account of both.
Sorry, I've lost you.
I'm sorry, I'm going too quickly. We're on page 144.
Yep.
This is the obviousness over Heller again.
Yes, right.
So in those first two paragraphs, Dexcom's case 336 to 338 and 339 to 341, Abbott's case. So both sides' cases have been recorded and considered. There's no basis for saying that the judge didn't hear or think about both parties' cases. And then at 342 to 356, I don't propose to go through the detail of it, but to cut a long story short, the judge considered Abbott's case that implementing a device starting from Heller would pose various manufacturing difficulties, and he rejected that. He rejected that case by detailed reference to the evidence, as one can see, going through there, the written evidence and the oral evidence. Then at 357, after that section, the judge is clear that he doesn't accept Abbott's approach in framing the route from Heller to the claim as a copious set of 12 individual decision steps, but he says that he can nevertheless adopt that structure, notwithstanding his misgivings about it, to analyse the obviousness case, because he eventually decides, even if I consider all of these steps as steps, it's obvious. I'm not going to take you through all of them. We just need to get from the start to step 4 for present purposes. So at 359, the judge starts with step 1A, decide to take forward figure 32. Well, as the judge rightly said, that's not really a step. You've got to start somewhere. There it is. 1B was dismissed at 361 in light of the evidence. The judge said that was just part of routine design development by the skilled team.
Can I just ask about that? I mean, my understanding is that step 1B is an alternative to step 1A, and therefore actually it doesn't matter either way.
That's right. Yes, that's very fair.
It's because the judge explains earlier that the 12 steps include 2 alternatives.
Yes, no, that's very fair, my lord. He does say at the end that it's part of routine product development, but what my lord says is absolutely right. So then step 2. This also was just an act of routine design, the judge decided. Steps 3A and 3B, he arrived at the same conclusion about, because he said essentially it just involved the skilled person understanding as they would that the Heller figures were not detailed design drawings, but were schematics. And in that light, just adjusting them this way would be completely routine design optimization. Next is step 4. Now, I think some of the confusion, and I fully accept it may be that the drafting of my skeleton argument adds to it, in which case I apologise, is because the judge here says use figure 33 as the starting point. But of course, this isn't, as I think my learned friend said this morning, this isn't a starting point in the sense of being the starting point of the judge's analysis of obviousness. Rather, at this point of the notional development of an analyte monitoring assembly, so-called step 4, the skilled person now needs an insertion device for the sensor. And figure 33 describes and illustrates an insertion device according to Heller, so the judge says it's obvious to start from that disclosure in the very next figure for the insertion device part of the analyte monitoring assembly. So as the judge rightly said, this isn't really a step at all. Heller presents the menu, and figure 32 itself doesn't illustrate an insertion device, but one is plainly required. A skilled person would know that. And in the very next figure, figure 33, they're taught one. This part of the analysis is no more complex in my submission than that. Figure 32 describes a sensor without an insertion device shown, and that's an alternative sensor to the main embodiment that's been, the main configuration that's been described by figures 1 to 31. Figure 32, on the other hand, isn't an alternative embodiment to those two. It describes a particular type of insertion device. And when charting your way through the menu, it could be used with the sensor of figure 32, or presumably with a different one. For example, the configuration of figures 1 to 31. My learned friend relies on the fact that in paragraph 216, which we don't need to turn up, the judge referred to the figure 32 as being an alternative embodiment. It is, but it's an alternative to the embodiment of figures 1 to 31, not 33. The figure 1 to 31 embodiment is the one where the two parts of the device are separated, as described in Heller at paragraph 215 for my Lord's notes. My learned friend showed you that this morning. The figure 32 embodiment, by contrast, is an integrated one, where the transmitter is disposed on the sensor. Figure 32, then, separately of describing either of those two embodiments, teaches an insertion device. And there's no reason to suppose that that teaching can't be applied.
You said 32, I think you meant 33.
I'm sorry, I certainly did mean 33.
32 is an integrated sensor, but it lacks the insertion device.
Correct.
So you need to get an insertion device.
Yes, you turn over the page and there it is.
Yeah.
And so that figure 33 isn't an alternative to 32. 32 is an alternative to 1 to 31. And if you need an insertion device, well, there it is in figure 33. So the description of figure 32 as an alternative embodiment isn't inconsistent at all in my submission with taking forward the figure 32 embodiment together with the learning about an insertion device gleaned from figure 33. It's an entirely reasonable way to approach and take forward the Heller teaching, and the judge was certainly entitled to find that it was obvious to do that. The judge's fundamental point is that the teaching in Heller that corresponds to each of figure 32 and 33 is just about different things, different aspects of the overall unit. There was nothing in principle to stop him from accepting evidence that a skilled person would apply the teaching of figure 33 to the integrated device of a sort set out in figure 32. And so that really is the meat of ground one, but I just want to deal with my Lord Justice Arnold's questions from Monday morning, where question one was, is it the correct reading of the judgment to say that the judge concluded it mattered not whether you start with figure 32 or 33? And I submit the judgment isn't so clear as it might be in this respect. I don't disagree with anything my learned friend said about this morning, in the sense that it's tolerably clear. The one thing the judge did certainly analyse, because as we've seen looking at the initiation of his analysis of Abbott's steps, he started with figure 32 and added figure 33 in at step 4. There are parts of the judgment that do appear to suggest one could start from figure 33, but what he certainly has analysed fully is starting from 32 and getting to 33. Paragraph 47 of my skeleton, which my Lord Justice Arnold referred to, simply recounted the judge's finding at 374, and I used the judge's words from that paragraph. So I do accept that there are parts of this judgment that could be read as suggesting it doesn't matter whether or not one starts from 32 or 33. Certainly the judge considered the obviousness case fully from figure 32. But I pause to say that in circumstances where the skilled person wants to produce a device having a sensor and an injection device, it might be surprising if a hugely different result came out of the analysis, whether one's starting from the type of sensor that they're interested in and then adding an injection device that's necessary, or whether they start by saying, oh, I like that injection device, and then decide what sort of sensor to put it with. As I said, there's no need to chart a linear course through the document, given that it has to be read as a whole. So this distinction might come to nothing. But certainly, the focus of the judge's analysis, the one thing he certainly has analysed, is starting point of figure 32, and at step 4 in that, the Abbott structure of the analysis, adding in the teaching of figure 33. My Lord then asked us, if the starting point is figure 32, what are the differences between figure 32 and the inventive concept of claim 1? This is essentially the central part of the Pozzoli analysis, of course, that we're being asked about. Figure 32 differs from the invention of claim 1 because figure 32 doesn't disclose the associated insertion device, as my Lord Justice Lewison put it to me a moment ago, to facilitate the deployment of the analyte monitoring arrangement, and in which the analyte monitoring arrangement is housed prior to being deployed. Should I say, for the reasons I've given?
And does it therefore follow that it also doesn't disclose a housing which covers both the sensor?
Disclose in terms, I think I must be right, yes.
Yeah.
But I say that the judge was entitled to find that obvious. Particularly in light of his finding that you would understand that these figures are schematic and you would have to shuffle things around to make everything fit. So that's the beginning and end of it, really, but for completeness, I want to make sure I answer my Lord's third question, which was that if the starting point were figure 33, what would the differences be between that and claim 1? It's effectively the opposite answer. So figure 33 differs from claim 1, the inventive concept of claim 1, I should probably say, in that it doesn't specifically disclose the analyte sensor in an integrated arrangement, that is to say, including a transmitter and power source. And whilst the bias mechanism is shown, it's not specifically disclosed that that's used to retract the deployment mechanism entirely within the housing after deployment. So to put it more informally, one either starts with figure 32 with an integrated device and looks for an insertion device to use with it, and it's in the next diagram, or if one's attention is caught by the insertion device, you can use it with an integrated device of figure 32.
You can choose your pudding before your main course if you want to.
Absolutely so, yeah. It doesn't matter what it is about the menu that made you go into the restaurant, ultimately you're going to eat everything. So ultimately we say the judge didn't embark on his analysis from a wrongfully hybrid...
I should have thought of this on my own. Suppose one takes the starting point, as you say the judge did, and I see the faults of this, as being figure 32 for some bits and figure 33 for other bits. What then?
think it's then the housing, isn't it, that we've got to rejig. I think that's the difference. I'm just thinking on my feet. I think that's the bit that I say is obvious in light of the fact that these are schematic diagrams.
What about coupled two? I mean, appreciate that you'll be addressing that when you come
I will.
Four.
My central submission about that, as you've seen in writing, is that it may not matter very much.
I'm sorry, say that again.
I said my central submission, certainly the difference between coupled to and operatively coupled may not matter very much.
No, but
you're asking me, is it there?
I think it's probably better to deal with this when we come to ground four, so I'll postpone my question. Thank you.
I'm grateful. So on ground one, ultimately where we get to is that the judge, I say, didn't embark on his analysis from a wrongfully hybrid starting point. I think one can get a bit carried away with the idea of a starting point altogether. One reads the starting point is having read the document as a whole with interest in my submission. So although I don't at all deprecate the asking of the questions we've been asked, we've got to adopt this structure because of the way the judge has approached it. But actually, I'm not sure one really even formally needs to identify a starting point. The question is, what are the things that you would glean from reading the document as a whole with interest, and how would you take them forward? And if that involves combining different insights from a document, the question is that combination of insights an obvious thing to do? And I say that in light of the fact that the document is structured in such a way that one has to combine insights from the document in order to make a working device, coupled with the evidence he had, and the insight the skilled person would have that these documents, these diagrams are schematic only, it was open to him to find the claim obvious. Also, the judge set out a considerable amount of evidence he relied on to arrive at this conclusion. He referred to it at various points in his analysis and explained which evidence he preferred and why. Considered both sides' evidence. So at 342 to 354, the judge considered in detail, as I pointed you to earlier, Abbott's submissions about alleged manufacturing difficulties. And then at 369 to 374, when discussing Abbott's fifth step, which is changing the dimensions of figure 33 to accommodate the figure 32 sensor. That's changing the dimensions of figure 33 to accommodate the figure 32 sensor. I'm sorry, I confused the numbers there. Having looked in detail at aspects of the evidence that were relevant, the judge assessed it at 374, which is on page 154, as ultimately meaning both parties' experts arrived in the same place, namely a modified version of the figure 33 device used automatically to insert the integrated sensor transmitter unit with a housing of figure 32. My central submission is that's a conclusion the judge was entitled to draw from the evidence without an error of approach. He didn't get there because he used a hybrid starting point, even if that would have been a wrong thing to do. He just didn't do it. He got there because he considered the evidence supported that the skilled person who implemented the figure 32 embodiment could work from the very next figure to produce an insertion device, which he or she would know they needed. That doesn't require and didn't include him committing any error of principle or approach. So, my lords, that's it on ground one. Ground two, I can take rather more briefly. The central theme of my position is that this one really does just comprise a criticism of the judge's appraisal of the evidence. There doesn't appear to be any error of principle identified here. Rather, Abbott's argument on this ground takes more the shape of, well, we think the judge got the answer wrong, so he must have approached it wrong, and not read Heller the way we think that he should have done. Ultimately, we say that's not a proper basis for an appellate reversal. Now, I'll look to make that good as concise as I properly can, and I propose to structure my submissions by reference to Abbott's written submissions on this and just answer those. So let's turn them up. It's a core tab 2, and we'll start on page 31, paragraph 71. So here it said the judge treated the patent as merely a high-level disclosure of the general concept of a single integrated all-in-one on-body unit. It's not said to arise from any particular error in how the judge directed himself, nor from a particular instance of construction. Instead, it's just said the judge's view of what Heller taught is wrong, and as it is on its face, that's not the basis for an appeal. Now, a central part of their argument on this ground, though, is identified at paragraph 72, where they say the judge held at J345 that the skilled team was not attracted to the figure 32 embodiment by the single substrate disclosure, but was attracted more generally by the idea of the single integrated unit and advantages that flowed from it. My lords, can we turn that up, please? So that's paragraph 345 of the judgment is on page 145. And it's core bundle tab 6. If my lords could please read 345, and then I'll make some short submissions about it. So my lords will recall the bit of the skeleton that corresponds to this that I just read out to you says that the judge held at 345 that the skilled team wasn't attracted to this figure 32 embodiment by the single substrate disclosure. I say this is an unhappy basis for the ground of appeal in two respects. First, because here the judge is just recording the evidence given by the experts. He didn't in this paragraph make a finding at all in my submission. So on its face, this ground seems to start from a criticism of a finding said to be found in the paragraph where the judge didn't make any finding. Secondly, it would anyway have been a perfectly available finding to him if he had. It has basis in the evidence for exactly the reasons clear from this paragraph. The judge has then gone on to consider how the parties engaged with that evidence. And in particular, he does so at 349. Could you just read that short paragraph yourselves, please? So between 345 and 349, the judge has recorded the evidence that Abbott doesn't like. He's recorded how Abbott sought to challenge that evidence, and he's considered that challenge. On doing so, he decided that he's not persuaded and that the challenge to it fails. That's a perfectly proper evaluation of the evidence, considering the position put forward by each side and then preferring one over the other. In truth here, Abbott just objects to the choice that the judge made. Abbott's next submission in this respect, in their paragraph 72, is that the judge ignored all the inconvenient details of the prior art and the reality of the marketplace at the time and for many years after the priority date. Now, as to this, we just say that the fact the judge didn't make reference to every aspect of what is said in the prior art would not be a proper criticism. The judge doesn't need to burden an already long judgment with all of that, and it would be positively unhelpful often to do so. Nor did the judge need to analyse and recount every last detail of the relevant market. The judge simply had to hear and consider all the evidence, reach a global view in the round on obviousness, and explain a basis for that ultimate view. And Abbott, for ground 2, can't properly say that he's failed to do that. Next, if you could please read paragraphs 74 and 75 of Abbott's skeleton, that's pages 31 and 32 of the bundle. So in my submission, this is a pretty clear attempt just to deprecate the evidence of Dexcom's evidence by looking to elevate Abbott's. The focus of this submission seems to be that the judge failed to prefer Dr. Schumacher's evidence over his Dexcom counterparts, notwithstanding that Abbott says Dr. Schumacher was the only witness with relevant sensor expertise. But of course, the judge is entitled to form his own view of which witness was of most assistance to him, and more than that, he explained why he treated their evidence as he did. I don't propose to take you through it because there's quite a lot of it, but for my Lord's notes, the judge gave a detailed appraisal of Dr. Schumacher as a witness between pages 73 and 77 of the judgment, that's paragraphs 19 to 38. Even accounting for any increased scrutiny given the judge's delay, it's hopeless to ask an appellate court to go back and unpick this sort of impressionistic assessment that the judge was entitled to make, especially when he's given cogent reasons by reference to the evidence for the impression he reached. So the point about the balance of evidence at a general level is unconvincing. The substance of this ground is that Heller is said not to give enough information to the skilled team actually to go and manufacture the embodiment of figure 32. But again, in the section of his judgment I've already shown you at 342 to 349, the judge heard the evidence subject to those impressions he's recorded and explained of the witnesses, and he reasoned his way to a conclusion that making the figure 32 sensor with a CGM device would not pose manufacturing difficulties for the skilled team. That's 342 to 349. Abbott says the judge shouldn't have found the necessary approach of manufacturing to be inevitable in any practical implementation or minimal. Rather, it would prefer a finding that that was highly creative. But this is just another way of saying that they disagree with the judge's conclusion about what's obvious. There's no error of approach. And then finally and briefly, as I identified in writing, there's one further central difficulty for Abbott on this ground, and it's this. It's not a new point, it's the one Dexcom raised squarely at trial. It's well established that a patentee can't defend an obviousness attack by pointing to some difficulty of working the prior art if the patent in suit also does nothing to address that difficulty. The easiest place to find that principle is the judgment of this court in Phillips and Acestech, and I've put the relevant part of that under paragraph 60 of my skeleton for my Lord's notes, but we don't need to go through it now because it just says in more elegant prose exactly what I just told you. I said Dexcom had raised this at trial, and for my Lord's notes again, that's at 101B of their closing, and that's reproduced under the next paragraph of my skeleton 61. So the judge was entirely able essentially to discount this perceived problem anyway when assessing obviousness also for the Acestech reason. But in fact, he did consider it, he dealt with it in detail on the evidence, and he provided an answer with basis in that evidence. So that's the end of ground 2. Ground 5 next, as to which I will also be pretty brief. The judge reasoned this very briefly himself, and I certainly accept it might have been helpful, not least to me, if he had said a little bit more. But we don't consider there's a good basis here for saying that he fell into error, and in any event, the point's a really very simple one. This is a ground where we need to be a bit careful just to zoom out a little and ask ourselves what we're asking ourselves in my submission. We, of course, must and will examine the detail of Abbott's submissions on this ground properly, but it doesn't hurt to stand back first and consider what questions really posed here, and it's this. In the context of a medical device, which plainly needs to be kept sterile, and the evidence showed that in case it were necessary, would it be inventive to cover off any opening in that device by putting a cap on it? Now, my learned friends admirably understated acceptance this morning that that might be less work than converting between manual and automatic operation is fair, but not really enough. We say that the judge can really be forgiven for not adding pages on the topic to an already long judgment, given how straightforward this question is. And I'm bound to observe that, frankly, on its face, the answer the judge reached is a pretty unsurprising one. Let's look at what he did say. It's quicker, probably, if I ask my lords just to read paragraphs 384 to 387 of the judgment, which are, they're on page 156 of the Bible, core 6.
this is all about claim 2, isn't it?
That's right.
And I think Mr. Mitchison's point was that the cap has to seal the sensor electronics.
We're coming to that, Mr.
the-
I think
not
I
the-
understood
not
the
necessarily the needle.
Yes, I think there were two points. One was, he says, as I understand it, there isn't really the evidential basis for saying this is obvious at all. Second is, one cap isn't good enough because you've got to seal the sensor electronics. And I'm dealing with the first of those
Right.
now, and then I'll deal with the second one very briefly as well. So the judge considered it obvious to put a cap on the housing for reasons of safety, to prevent injury by the sharp needle, or as an alternative option for maintaining a sterile device. That appears to be his sole basis for dismissing the inventiveness of claims 2 and 3, but it's a reason, and in my submission, a perfectly reasonable reason. The core of our position on this is essentially, as I expressed at 82 of my skeleton, which just says the judge was entitled to consider, perhaps to over-engineer a very simple insight into 3 parts. First, that it's obvious that a fundamentally medical device needs to be sterile, and that requires it not to be open to the elements. Second, that any opening therefore needs obviously to be covered. And third, it would be obvious to the skilled team needing to cover an opening in the device to cap it. The first of those 3 steps is an unsurprising one, but the judge may have got there in light of what he found to be Heller's description of packaging of the insertion kit in general terms along with sterilisation. That's paragraph 384 of his judgment. Certainly, given that finding he made, there's no room to say he didn't consider the need for a sterile device. And from there, the second and third of my points really do flow pretty inevitably. Dexcom led evidence from Mr. Varda that adding caps to maintain a sterile environment was very commonly used in medical devices generally. Let's look at Mr. Varda's cross-examination on this very briefly. It's Supplemental Bundle, tab 7, page 145. If you could read, please, in the internal transcript pages, 327 at line 14 down to 328 at line 19. And I'm afraid it's asking for you to continue reading to 23.
On page 328.
I assume so, yes. So 3 quick points to make about this. First, at a general level, Mr. Varda is clear that caps are very common in medical devices, for example, to preserve stability. They're well known and well understood to skilled people in the area. Second, the evidence isn't limited in its context to any particular text in Ethelfeld, although that is the section of my learned friend's cross-examination that this comes from. Mr. Varda here, though, is making statements, I submit, generally about what the skilled person would know about. And finally, I have checked, and this evidence was specifically cited to the judge by Dexcom. For my Lord's note, that's paragraph 44 of their closing, which you can see in page 159 of the supplemental bundle, but we don't need to turn it up. So this, we say, is clear evidence from which the judge could reach a position on claims 2 and 3. And as I said in writing, just standing back for a moment, this isn't attributing some great degree of ingenuity to a skilled team, which after all is experienced in medical devices. Next, there's the point that Abbott raises that the particular arrangement of Heller relied upon is open in 2 places, so 1 cap won't do. But to put more than 1 cap wouldn't take a device outside the claim. My Lords could remind yourselves of claims 2 and 3. We take them from the judgment on page 104. 2 there is about the first hole punch. The short point is that they are comprising a cap. So comprising a cap and having another cap would not take you outside of the claim. My last point on this ground is the same
That's
as...
all patent speak, isn't it? Comprising as opposed to consisting of.
Indeed, yes. Sorry, I should unpack that a little, shouldn't I? Comprising is not limiting of what else there is. It just means it has that and maybe some other things. So my last point on this ground is another one that Dexcom ran before the judge, and it's related to the same ASUS Tech principle that I took my lords to in relation to ground 2. I'm just going to show it to you and say that it too provided the judge with a basis, starting with the evidence for his conclusion here. The quickest way to do this, I think, in Supplemental Bundle tab 10, pages 184 to 186 is an excerpt from Dexcom's closing. If you could please read paragraphs 127 to 131 of that closing, and then I'll make some short submissions about it to conclude on ground 5. So in my submission, Dexcom has here provided a judge with a further basis for finding that he did, and the point runs in essentially 3 stages, as we understand it. First, in his cross-examination, Dr. Schermacher's position, that's Abbott's expert, on the cap feature seemed to be that since Heller suggests using a sterilised bag, a cap would not be obvious. But Dexcom said, and with apparent good reason, Dr. Schermacher was there applying the wrong obviousness standard, and they referred to his cross-examination, ending with Dr. Schermacher saying, I wouldn't say it's perfectly obvious because you can have a sealed foil at the end as well. It's not obvious to use the cap. So in other words, the witness seemed to think it couldn't be an obvious solution since it was not the only obvious solution, but that approach is bad in law. In any event, the patent doesn't claim a specific form of cap, and doesn't put forward any technical advantage for the cap over, for example, a sterile bag. And finally, the cap of claims 2 to 3 is a purely arbitrary selection on that basis from the prior art, and an arbitrary selection is definitionally obvious. Mr. Varda's evidence explains that use of a cap to cover the end of the insertion device was one of many obvious solutions available to the design engineer. And that is quoted at paragraph 130 of Dexcom's closing, which you've just read, referring to Mr. Varda's first report at 10:23. So that's it for ground 5, which leads me with some trepidation to grounds 3 and 4. Part of the reason that I spent time near the start of my submissions on the approach that the controller takes on this appeal is because of the very unusual position he finds himself in on grounds 3 and 4. I said before that we found this to be an unusually difficult appeal to assist with, and it is clear that to a material degree the judge has got himself in a muddle, as we've accepted. Where we get to then is this. There are 2 grounds which on their face appear to us to have some force. Incidentally, in their supplemental skeleton, my learned friends seem to have understood there to be a material distinction between my saying a ground had force and the other one had real force, or something that was not meant to be, suggesting the force of one was unreal or something. That's a distinction I didn't intend. There are 2 grounds which have some merit to them. It's for my lords to decide, and I'm going to try and assist you with what the best points that are available in the contrary direction as to whether that's a reason to find the judge's conclusion to be unsafe and need to be reversed. But there is some force where they say the judge did this, we say it appears he did.
Yeah, well, what we would particularly be grateful for your assistance with is this. It's one thing for the judge to be shown to have made an error.
Yes.
The question that follows is, what should we do about it? Now, we discussed this before the short adjournment to some extent as to the possibility of reconsideration or remittal. The question I think perhaps useful to be posed at this stage: assume that we reconsider, what then is the correct conclusion?
I am going to help you with that. I'm not going to advance what the controller thinks is the correct conclusion. What I will advance is what I think the best thing that could be said by somebody who wants to urge you to a conclusion in favour of a notional respondent. And I say that not to disown my submissions, they're my responsibility and my fault, but it's important that I'm clear about the controller's role. We are not here to give the controller's view of the merits.
No.
And that's part of why we have gone further on grounds 3 and 4 than simply to say they seem to have a point here, because otherwise all that does is displace the judge's judgment in favour of the controller's, or worse still, mine. That cannot be how the system's supposed to work, and for that reason we did try to ventilate some points that a respondent might take, even though we're not really in a position to flesh them out the way that a proper respondent would be expected to. So I will excuse me.
I'm sorry, you can carry on.
Right, so I will assist you with, I think, the best that can be said in favour of reconsidering and finding that the patent is still obvious. I will give you the outline of what I think the best points would be. I'm going to do that on ground 3 and on ground 4 separately. There's a limit to my, and I also want to be clear, the spirit in which we're doing that, just to be fair. Excuse me, my lord.
Some of the cases which have involved lengthy delay in producing judgment have expressed themselves slightly differently about what the court is trying to do.
Yes.
Part 52 of the CPR entitles us to revert to allow an appeal if the judge was wrong,
Yes.
or if there's been a procedural irregularity.
Yes.
Is there any difference between the judge being wrong on the one hand and this court being satisfied that the judgment is safe, which is the way that some of the cases seem to express the test?
So,
if there is a difference, what is it?
Well, Lady Justice Falk addresses both of those in the. Maybe it would serve for me to just deal with the deal. If I take you through Lady Justice Falk's judgment on phones for you, because she makes clear that the test is no longer that something must be plain, a factual finding, for example, must not just be plainly wrong in order for this court to reverse. Where there has been delay, you will go further and say, if something has been missed out, was it material, was it potentially material to the outcome such that the conclusion is unsafe? So where the judge has left something out of account, the court will go further. Now, I must confess, I have some difficulty with understanding why it is that Lady Justice Falk considers that to be different from what this court does anyway, because on the basis of, for example, ICOS, the judgment in Actis and ICOS of the Supreme Court, leaving a relevant factor out of account is the basis for a re-examination. And if then this court, one would hope this court always considers whether it should do what it's about to do when it reverses a judge. So whether there is really a difference based on that distinction, I will confess I have struggled with.
Yeah, it's what she says at para 222, I think.
Yes, so my submissions on the law, I had planned to take you through what the judgment, how it arose, but I don't think I need to do that, so what it was. The delay there was 15 months, but it was after an 11-week trial. It's an extremely complicated competition matter where there were, Phones for You was one of 2 big retail providers of connections to, of mobile phone connections to consumer users. And they would provide them from the big mobile phone providers about whom we all know. 3 of those mobile phone providers decided they were not going to renew their contracts with Phones for You. Phones for You went bust, and Phones for You then accused them of anti-competitive behaviour in having simultaneously or close to it, decided to terminate their contracts, leading to phones for use failure. So that was there was an extremely complicated action in an 11-week trial, and the delay was of a similar order to that in this case. My submissions on the law, the sort of summary I was going to draw out is as follows. So the starting point is the summary that Lady Justice Falk produces at paragraph 218. My Lord, sorry, I should have said this judgment is at tab 11 of the authorities bundle. The danger of an appellate court relying on a selection of bits of the evidence without their broader context, the island hopping danger, is more and not less acute when an appellate court is applying additional scrutiny because of delay. That's Lady Justice Falk's 220. That said, delay is not carte blanche to an appellant to challenge any factual findings it dislikes. The key questions are first, whether there is a basis for believing that there may have been a causal link between the excessive delay and the alleged errors. That's 221. And second, whether the judge's decision is safe or whether to allow it to stand would be unfair to the appellant. So I think that's the key question, but I should like to think that's something that this court keeps in mind whenever it
Would you
writes
say it's the proposition that one of the things, I don't think it's spelled out by Lady Justice Falk, but no doubt she had it in mind, is that one of the remedies that's available to the appeal court is a retrial or remittal of specific issues. And that may perhaps be the distinction, because it may be that on a question of fact or evaluation, particularly where there's been delay, the court may conclude that there is either an error or at any rate that they're not convinced that the judgment is safe, but they may not be in a position to reach the opposite conclusion that the judge has done, and therefore the way forward is remittal or even a full-scale real trial.
Yes.
Might that be an
Yes, that's what
explanation of
I'd
the
not thought to put it
distinction
that way.
between
Yes.
safe and wrong?
Yes, yes, that could be right. Yes, because safe is contrasted in that paragraph I just referred to. The opposite of safe is one where it's to allow it to stand. Well, those are the two considerations. You've got to decide whether it's safe and whether to allow it to stand would be unfair to the appellant. So I think that probably does fit with my Lord's analysis, yes. Certainly, my Lords are balancing unfairnesses, if I can put it that way, when deciding which way to go forward. And we take no joy in the suggestions we're making about ways forward. I've explained, I hope carefully, why we've taken the approach that we have and said more than they seem to be right about these things. And we fully appreciate, particularly given the history, the protracted history, that almost all options going forward are unattractive. But I seek to provide some assistance with what the available options are.
Yeah.
And then Lady Justice Falk then returns to the issue of time taken to write judgments at 322 to 328. I should just highlight that. I don't propose to take you through it. And 328 is the one paragraph that I read to you before about not allowing this to get out of hand and become a weapon for disgruntled appellants.
Yeah.
Which is not meant to be pejorative about the appellant in this case, just to be absolutely clear. So, my Lords, where we get to is that on these two grounds, on their face, they appear to us to have force in the sense that where they allege the judge did or failed to do something, it appears to us difficult for counterparties to suggest that that is not true. So I propose to take these grounds very briefly to conclude my submissions on this appeal. It will be very brief, I'm afraid. I would like, no doubt, to give you more assistance than I can, but I will give you as much as I can, mindful of the limitations on what we're able to do that I've already emphasised. So ground 3, very briefly, we do agree that the judge's judgment is not clear, and there does appear muddle does between the housing of the integrated unit and the housing of the insertion device. In addition, and perhaps somewhat in the judge's defence, having reviewed the closing submissions with a degree of hope from Dexcom at trial, it's fair to say they weren't very disciplined about this distinction either, and my learned friend took you to an example of that today. We do say there is room to say that this should not be reason to reverse the judge's conclusion on obviousness, and that there is a basis on the papers for finding that these infelicities in the judgment don't make it an unsafe one, or rather, to take the formulation we've just been discussing, that my lords could reconsider matters and arrive at the same conclusion. This is the argument that I put forward in my skeleton at paragraph 67. I'll flesh it out very slightly now. And in particular, in the middle of it, I'm going to have to deal with what really is the central point on these grounds, it seems to me, which is the movement from manual to automatic. I will say up front, just to be absolutely clear, I accept that figure 33 is automatic as a matter of disclosure. So the first step is that figure 33 of Heller appears to teach an insertion device having a form that includes a housing within which the sensor arrangement, injector device, and associated bias mechanism are found pre-deployment. Number 2 is that there is disclosure from Heller of packaging all the features together as a single package. And my lords have seen this part this morning, but we'll go back to it. It's a description that supports figure 33, which is in paragraphs 255 and 256.
You're going back to Heller or judgment?
I'm sorry, it's in Heller.
Heller.
Yes, the supplemental bundle, tab 2, page 99, 255 and 256 are the paragraphs. Sadly, the paragraphs of the judgment and the paragraphs of Heller have been read at this point. Figure 33 itself, in case you want to flip back to it, is on page 78. Paragraph 255 and 256 on page 99, I'd ask you to read. So 255 discusses the option for the whole arrangement to be pre-assembled, to be sold together as an insertion kit. And the judge highlighted this and referred to this at paragraph 222 of his judgment, for your note. This plainly suggests, the respondent might say, that pre-deployment, the sensor and insertion device are safely located within at least some form of housing and can then be deployed by means such as it are embodied in figure 33. Next comes the manual deployment question, because I do accept figure 33 discloses an automatic deployment. I think the best I can do on this comes in 5 parts. A preliminary point is that at paragraph 153 of the judgment, which we were taken to this morning by my learned friend, the judge says, talking about construction here, and the arguments on construction. At the start of trial, Dexcom's argument was founded on some evidence given by Mr. Varda in his first report regarding integer 1.9, which, as my learned friend says, 19 and 110 are the 2 central integers on this dispute. He interpreted coupled to the housing narrowly because he considered the claim was limited to manual insertion. My learned friend said this morning that that was right. He was there and I wasn't. But I have no reason to suppose that's not right. So Mr. Varda, whose evidence on obviousness we look at later, plainly at the very least had manual insertion in mind. Next comes a disclosure from Heller itself, which you're also shown this morning, but I think it would be useful just to show it to you again. It's only a short part I'll ask you to read. So supplemental bundle 2, tab 2, it's paragraphs 205 and 207, 205 through to 207, which is on page 94. And you have been shown this morning. I'll just make a brief submission about it when you remind yourselves of it, if I may. So my central submission here is that it expressly contemplates the insertion device being injected manually or mechanically. We would say that's manually or automatically for this purpose. My learned friend had a point about that it says the force applied can be manual or automatic. We think that's a distinction without a difference. In context, we say it's plain that the skilled person would understand that the device itself, the insertion device, could be manually or automatically actuated.
Well, indeed. Would you submit that there is disclosure in this passage of either of the following two things? Firstly, that being effected through a housing of the insertion device. Secondly, manual insertion but automatic retraction.
But disclosure here, no, I have to accept they're not here. The question is whether the alteration to those would be obvious, because they're not part of the disclosure. In that respect, our learned friend referred to the end of my Lord's judgment in respect of the Ethelfeld prior art, where he didn't accept the obviousness case. But it's important to bear in mind that that was a case where one had to go from manual to automatic, effectively, among other distinctions my learned friend relied upon. And we say that it's perfectly reasonable to suppose that going from manual to automatic configurations might produce more and different difficulties compared with going from automatic to manual. Ultimately, in an embodiment like figure 33, after all, where it's a biased spring, the distinction is just about biasing the spring the other way out. If you attach the spring at the other end, then it pulls the thing out instead of pushing it in. There are many aspects of the technology in this case I have found extremely challenging. That isn't one of them. Finally, there's the point that my Lord Justice Arnold put to my learned friend this morning, that it may well be that the distinction between manual and automatic insertion is just something that wouldn't be of great import in the context of the invention as described, which is why it's slightly breezily mentioned here without descending to great further detail. So I think that's about as much as is available on the materials we have.
But
To
if
sup-
you start with header,
Yeah.
which is I think you accept, although there is this brief reference to manual insertion, really discloses automatic insertion. Why would you want to change that to manual? What would be the motivation for going? It sounds as though it's going backwards.
There are no findings that support that motivation. Question I've posed to myself more than once in the last week, but I just don't have anything.
Yeah.
So I think those 5 points, having done what certainly felt like an exhaustive search, even though I'm sure it wasn't, is about the best of what I can put together to support the suggestion that it's really not a big deal, consistent with its slightly breezy disclosure in here, and the fact that you might expect that going from automatic to manual is rather easier. Pushing something in that was previously automated, rather than the other way around, is not a similarly difficult conversion.
Yes, but I come back to the point, I apologise for asking the same question again, but it's just to be sure that you've had a full opportunity to do your best to answer it. Even if you make that supposition, where is there any suggestion, let alone disclosure, in Heller of manual insertion plus automatic retraction? And you said previously that it's technically possible because you can bias the spring the other way around. I accept that, of course, but where is that even suggested?
No, except at the levels of general disclosure about manual insertion, we don't think. I'm not aware of anything further than that. I'm afraid so. Yeah. I'm sorry not to provide a fuller, even on the second time of asking, not giving you a very full answer to your question, but there it is.
You're performing your function of assisting the court, and we're grateful.
Yes, I mean, I suppose the difficulty in the question actually is my Lord Justice Lewison's question. The two are linked, which is that given that it is really quite easy to achieve, because it would be an automated retraction, but why would you is the difficult question, and there are no findings as to that. Yeah. That's the difficulty. I don't think there's really much mileage in saying, oh, it's a problem that the skilled person couldn't solve, really.
But this is the force of Mr Vardy's evidence that was so often discussed in closing submissions and in the judgment about it's all springs and levers, or words to that effect. And of course, you know, from a mechanical point of view, of course, he was absolutely right. But as you say, the question is, well, what's the motivation? Yes.
And because of the approach taken in the judgment, there's no findings as a motivation to go from automatic to manual. I'm afraid I'm not aware that there's a finding there. Yeah. Just to complete the point on ground 3, I think it would then go through to say we therefore end up at an arrangement equivalent to the housing 1210, which is in figures 12A and 12B of the patent. That's page 40, but I don't think we need to turn it up. It would be equivalent in the sense that the purpose of that housing of the patent is to provide an environment for the sensor and the insertion device before deployment that is safe in the sense of protecting you from sharps, secure and sterile, and to give something for the deployment mechanism to work relative to. And the submission would go on that in those sections I just showed you, Heller does disclose something that serves that purpose. It forms the outer arrangement of the insertion device and contains within it the insertion needle and sensor electronics assembly. So on that basis, the judge's analysis needn't be upended, because the comments he made about the housing in the context of his analysis of obviousness would still be equally applicable to a correctly defined housing of the insertion device as disclosed by Heller. And I think that's about as much as I can do on ground 3, which leaves me just with ground 4 before I, subject to my lords, sit down. Again, we agree on ground 4 that the judge didn't, in the judgment, write out any proper reasoning in relation to the 2 features of claim 1, that the introducer needle be coupled to the housing of the insertion device, that is, which is integer 1.9, nor that it be operatively coupled to the housing of the insertion device, which is integer 110. He did construe these features of the claim. That's at paragraphs 148 to 149, which you've been taken to, and I don't need to go back to. As I noted in my skeleton at paragraph 71, one point that could be made is that these don't appear to be terribly important features. The nature of the coupling, I'll be clear when I say that, in the context of the claimed invention. What I mean by that is the coupled and operatively coupled language is used in the patent in a manner that seems to render them close to interchangeable, and there's not any clear magic to that difference. I'll show you.
So the judge's construction was that it meant something different.
Yes. But what significance there could be to that to obviousness in circumstances where the patent appears to use them in very similar circumstances is something that might be said, I suppose. I was going to show you some instances in the patent to make that good, only a couple. So for example, paragraph, I'll give you the list and then we'll just go to two. So the paragraphs in my list are 49, 68, 76 to 77, and 80 to 81. So let's look first at paragraph 68 of the patent. Page 14 of the bundle. This relates to figure 3. And it describes a power supply which is operatively coupled to a power conversion and monitoring section, and that in turn being coupled to a receiver processor, with no obvious magic to that distinction there. Figure 4 is then referred to in paragraph 77. And in that one, a primary inductive loop antenna is coupled to a square wave driver, which is operatively coupled to the control unit. Again, without any particular magic to that distinction, which would seem to bear on the importance of these features in the context of obviousness. Finally, the discussion of the embodied insertion device in the patent is figures 12C to G, and the description of that is paragraphs 119 to 121. That's on pages 20 and 21 of the bundle. (119 to 121). The short point here is that it doesn't discuss the interaction between the coupling of the housing and the introducer needle arrangement in terms which place any reliance on an important distinction or a distinction between coupled contrasted with operatively coupled. That's an observation that can fairly be made in my submission, but the fact remains that the judge didn't in writing go through the step of considering these features. Once again, putting forward some points that we think the respondent might try to take, we have limited ourselves to things, materials based in things that Dexcom put in issue. So, my lords, in fact, let's...
Just on this point, I mean,
yes.
it's not, I'm going to ask a question to which, in a sense, you can't answer, but I just want to air it in. One of the peculiarities, of course, is that if we imagine that the parties have not settled their dispute, and Dexcom were here as respondent, Dexcom would be on the horns of a dilemma. Because, on the one hand, they would want to support the judge's construction as it led to the finding of non-infringement of the G7 device, and they wouldn't want to be jeopardising that. On the other hand, they would no doubt be quite likely to support the judge's conclusion on obviousness, and they would they would have some difficulty, I suspect, in riding both horses.
Yes, I mean, I can't quibble with that, save to the extent that I suppose I'm not sure how appropriate it is to read in these commercial considerations, but actually, if they had a definitive finding of non-infringement and they were sure of their position on infringement, they might be perfectly happy for the patent to remain.
Yes, so they might...
A patent that stops the rest of the market and not them might be something that
so
Dexcom were perfectly happy with.
They might argue the case on the basis of they would ask the court to decide the construction issue first, and if construction is maintained, then they would quit the case.
Or if they were really daring, they could have just, yeah, I'm sure.
Yeah. Okay.
They could have just gone for infringement or bust if they wanted, if they were really sure of themselves, I suppose.
Yeah. Okay, thank you.
I'm not sure, yeah, I'm not sure how appropriate it would be for me to weigh those things in to my submissions, but I think that must be the right position. They would be on the horns of a dilemma if they maintained everything, but there may well be commercial considerations that made it unwise or not the choice they chose to make. My lords, let's take this last bit from Dexcom's closing, please, because I have based myself in there because that seemed to be the fair way to do this. I've not given myself a page reference, sadly. 114 to 124.
Where are we? 112, did you say?
Sorry, 114 of the
178 of the bundle.
Sorry, Tom.
178.
178 of the bundle, I'm told.
Tab 10.
Let's put the paragraph reference in as well. Yes. I'm grateful to my learned friend and sorry I didn't do that myself. In my note, so 178 is where this starts. So this is all part of a section that begins some pages up, going through the various integers of the claim. The bit I would ask you to read is the bit that considers features integers 1.7 through to 110. And so if my lords could read 114 to 124, and then I will try and unpack slightly how the argument proceeds, and then I propose, subject to my lords, to sit down.
Up to where, Mr. Buran?
114 to 124, please. So the first point to make is that my learned friend is absolutely right that this automatic manual distinction looms over this ground as well. You have my submissions in relation to it and I won't repeat them. We understand Dexcom's argument, which would be adopted to proceed roughly this way. First, figure 33 teaches an insertion device with a housing, and its insertion gun has a needle that's configured to move between a first position inside the housing and a second inserted position. That's described at paragraph 255, which I took you to earlier. Then 207 of Heller, which is bundle page 94, which I also asked you to read earlier, teaches a spring retraction mechanism, as my learned friend accepts. He says not in great detail, and I think I have to accept that. Next comes Mr. Varda's written evidence. My learned friend took you through this morning, and so I'm not going to spend a lot of time on it. He says essentially that I'm wrong about it just because it wasn't considering manual insertion. That just depends. There's two. You have my submissions on manual insertion as a general matter. Is it something that's obvious in light of Heller? Second is that point that I took you to from 153 of the judgment that Mr. Varda did apparently have manual insertion in mind in his report, and there was that paragraph of the judgment which says his construction arguments came out the way they did because he considered the claim to be limited to manual insertion, and my learned friend this morning told you that was correct. So with those as background music, the paragraphs of Mr. Varda's evidence my learned friend took you to this morning, and they say what they say, they are certainly terse. I don't pretend for a moment that they're a fulsome exposition of how you do what he proposes. But I do say, given the types of adjustments that are involved, it is possible to conclude the judge had evidence from Mr. Varda that supported the conclusion that the claim as a whole was obvious because Mr. Varda has considered all of the integers of the claim and has said that the implementation would be obvious, starting from Heller. An important distinction to draw is that one doesn't need to be able to find in the evidence an express statement from a witness that says this feature is obvious, that feature is obvious, and so on. Because, of course, the witness's opinions about what is obvious and not are of relatively low import in a practice case. Quite. So the question is simply, do these very terse, I can't pretend that there's more there than there is, do these paragraphs provide the judge with a basis from which he could decide they were obvious? At several points this morning, my learned friend says, well, there's no evidence that this feature is obvious, or that you would change from X to Y would be obvious. That doesn't matter. The question is, does the evidence teach the judge something which would be a fair basis for his global finding, considering all the matters that he had to consider, that the claim is obvious?
And in effect, is that the same as saying that we should decide that?
I think so.
And
Yes, I think
do
it
you
probably
say we have the materials to decide it?
Yes. I certainly say it is perfectly arguable that you have the materials, and I've done the best I can for you. I think that's as high as I can properly put it in the role I have. So the final part of the question then becomes, well, what happened to that evidence in cross-examination? Did it disappear? Mr. Varda was cross-examined about the effect that the modification, about the modifications that would be needed to figure 33 to implement it in this way. But the cross-examination didn't challenge his evidence that these modifications were obvious. It was put to him no higher than that the changes needed were substantial. I think you've been shown this morning, but it's at tab 7 of the supplemental bundle on page 152. And it's lines 5 to 22 that Dexcom placed reliance on, I think.
Sorry, it's supplemental bundle.
Tab 7,
yeah.
page 152, and it's page of the transcript 353.
Yes.
Lines 5 to 22, please. My submission is just it never gets higher than these modifications are substantial.
Yeah.
So the upshot, it would be said, is that there must be some form of coupling, plainly, between the housing and the injector needle in order for that needle to be deployed relative to the housing. And likewise, without some form of operative coupling to the housing, the bias mechanism wouldn't be able to retract the needle with respect to it. And ultimately, there is an arguable position that there's an evidential basis for finding that the claim, including that feature, is obvious, starting from the disclosure of Heller, taking all of those materials and considerations into account globally, rather than going on a hunt for a line that says this feature is obvious and a line that says that feature is obvious, and so on. Against that background, it would be said that the fact that the judge didn't spend particular time analysing the different types of coupling to the housing, when those don't appear terribly important to the implementation of the invention or the fulfilment of its purpose, would not be said to be a reason to find his conclusion on obviousness to be unsafe, or indeed wrong, even if he ought to have reasoned this feature out in his judgment, at least briefly. My lords, unless I can assist you further, those are the submissions of His Majesty's control.
Thank you very much, Mr. Brown. Mr. Mitchell, do you wish to reply?
Yes, please, if I may, my lords, I'll be as brief as I can. My lords, yeah, perhaps I don't deal with this. Your lordship asked whether anyone was aware of a case where remission had taken place in the last 20 years, and we're not aware of that. There was the Coflexit case, which I provided that to my learned friend yesterday. I don't think we need to look at it, but in that case, the parties sought to bring a new piece of prior art in the Court of Appeal, and the court, Lord Justice Aldous, Lord Justice Chadwick, said, we're not going to order a remittal so that the court below can think about this new bit of art. It's too late. If anyone wants to come along and invalidate the patent based on this new bit of prior art, that's up to them. So that was the closest we've come to. And I know there is a Frand case, I think, where your lordship remitted one issue, Appellant, and there was also, it was discussed, there was also refusal.
Yeah, that wasn't an obvious.
No, it wasn't. No, that was the distinction I was going to make. But those are the only
It would
two.
be odd, I think, to remit where there isn't an active opponent.
Indeed, my lord, because who's meant to put the arguments together? Who's meant to, there's no expert witness to recall if further evidence is required, as we submit it would be. We completely agree. But for the same reasons I'm going to come on to, we say, nor is it right for your lordships to determine on the material before you, on the facts of this case, that in fact the judge should or could have found the claim obvious based on his own construction. But I'll come to that in a moment. So that was remittal. The other point which my learned friend raised before lunch was the point about the respondent's notice. And obviously we haven't taken, not taking procedural point that he shouldn't be permitted to make the arguments he's made. But had it been Dexcom here, seeking to make a number of the arguments that my learned friend has made, we would have taken the point very strongly that they were not entitled to take these points as part of a respondent's notice because they were not argued below. And we say that is an important procedural issue which because we haven't gone through the formality of a respondent's notice, and because my learned friend is in a different position to Dexcom, then we're not taking the point because we recognise that there is a public interest in the controller being here. But had it been Dexcom, we would have had a big row about whether they were even entitled to make these points when they weren't taken below. And we plainly would have objected to any suggestion they needed extra evidence to buttress the points that they made, which we say are not in the evidence, and all of Ladd and Marshall would have applied, and we say there would be no basis for them to have called more evidence to say, oh, well, I didn't say that in my first report, but now I've been asked to think about it, it was obvious too, or whatever it might have been. So, my lords, we deliberately haven't taken procedural points with the controller, but one has to imagine what might have been the position had it been Dexcom here. And we say that would have underlined the difficulties which the so-called respondents' notice arguments have. The next point my learned friend took was a sort of overview of Heller, and he said, well, it's a mix and match document. It's a menu. You can pick a la carte from here, there, and everywhere. One has to be very careful, and your lordships may well be familiar with the suggestion. You can't use a previous document as a reservoir and just pick features from here, there, and everywhere. It applies for added matter purposes in patent law, and it applies equally to obviousness. It has to be obvious to pick the particular features that are said for the skilled person to do. And although we come down to the detail, we can come to the detail in a moment on how to combine those elements, it may be that there was material before the judge to say, yes, it is all right to combine figure 32 and figure 33. Just because figure 33 comes after figure 32 doesn't mean you automatically think of combining them, because of course there's a whole load of text in between the reference to those two figures in the document I showed you. They refer to figure 32, then they go back to figure 17, and they go through all those points. And of course there are other ways of inserting sensors in the document. That's figure 26. And the point, perhaps it's convenient to make it now, I could make it later, but I'll make it now. The point is that when it came to it, Mr. Vardy clearly didn't like figure 26, and he preferred figure 33. So that you have to have reasons to put things together. And if your lordships just go back to the supplemental bundle tab 12, and this is tab 12, page 201. This is Mr. Vardy's evidence about Heller, and I took you to the beginning of this morning, and then 8.65 on 201. He refers to passages at 254 to 256 of Heller, and then 866. He says two insertion guns are described. The first is depicted in para 26, and he goes on to talk about that. And then he says, penultimate sentence of 866, it would require substantial modification to use with an embodiment like that of figure 32 once that is contained in a housing. And then he goes on to talk about the second insertion gun, and he says at the end of 867, this is attractive to the design engineer because of its focus on safety and fewer user steps. And then he goes on to develop what he thinks the skilled person would do with figure 33. So it's clear there that when Mr. Vardy was talking about substantial modification, and the reason I asked him about that in the cross-examination passage, which my learned friend has just taken you to, is that he clearly considered that it wasn't actually that attractive to use figure 26, because that would require substantial modification. And he then therefore preferred figure 33. So you have to look at what's actually taught by Heller and what the skilled person would see about Heller. And it's not a case of just taking any part of any passage and putting them together. And when I cross-examined Mr. Vardy about figure 33 and said, well, it requires substantial modification too, doesn't it? He agreed with me. And that's because we say he was clearly not really liking the modifications to figure 26 that he explained here. So one can't just dip into the document without understanding what the skilled person is actually saying about each of these embodiments, and it's not an a la carte. Certainly not a la carte. Have your pudding first and then have the main course. You have to look at the document as a whole, see what it teaches the skilled person, and then only go forward with the obvious things based on what the skilled person would think. So that's the overview, I think, of Heller. Then my learned friend took you on to ground 5. And this is the point about the cap. And we say, although we submit that ground 4 is even stronger point, the submissions that my learned friend made on ground 5 illustrate the dangers of trying to characterise after the event the elements in this field. Because what he said to you, he said, would it be inventive to put a cap on? And if you say it like that, it makes it sound completely obvious to say, well, of course it wouldn't be inventive to put a cap on because caps had been used in the prior art. But the question is, would it be inventive to put a cap on in the way that's required by Claim 2? And Claim 2 requires additional features, not simply the choice of a cap. And if you go to it, it's on page 104 of in the core bundle. Where the judge sets out the claims. What it requires is it requires a cap, yes, but the cap must be configured to mate with an open end of the housing of the insertion device to seal the sensor electronics assembly. So there are two important further additions there. Firstly, it has to mate with an open end of the housing. And secondly, the addition of the cap has to seal the electronics assembly. The fact it's a comprising claim makes no difference because we're not saying that whether or not there's a cap somewhere else makes the difference. What makes the difference is whether or not the cap that you're adding seals the sensor electronics assembly and mates with an open end of the housing. And if you've got the wrong housing to start with, then it's difficult to construct the argument that you're putting the cap on in the right place. And if you have an open assembly, like you do in figure 33, it's also difficult to suggest that wherever you put the cap, it is sealing the sensor electronics assembly. So the important question is not, do you have a cap or not? It's how you put the cap on to the apparatus you've already decided it was obvious to make, and where that cap engages with the housing, and whether that cap seals the apparatus in the way that Claim 2 requires. So asking the question at a 33,000 feet level, oh, is it inventive to put a cap on or not, is not the right question. The right question is it inventive or obvious to put a cap onto apparatus in the way that is required by Claim 2?
So are you saying that there must be a single cap with a dual function, or could different functions be performed by different caps? In other words, could one of them mate with the open end of the housing and the other one seal the electronic assembly?
Well, it says it's a cap.
I know it does, but
there may be other parts of the device which are sealing other ends of it. That's not necessarily the question. The question is, yes, the question is, has the cap you have decided to put on for the purposes of Claim 2, is it doing those two purposes?
You read a cap as a single cap.
Yes.
You can't have two caps, one of which does one of the things that it's required to do, and the other does the other one.
Correct, and as we construe the claim. And of course, my learned friend said, well, there's no teaching of that in the patent. There absolutely is, and I took you, Your Lordship, to this morning. The figures of the patent, which show figure 12A on page 98. There's a cap there, 120, number 120 on page 98, yeah. Which mates with the open end of the housing and seals the sensor electronics assembly therein. And it's also configured to rotatably couple to the end of the housing. That's only an optional feature, so that maybe doesn't matter, but it does all of those things. So the suggestion from my learned friend that, oh, well, the reason that you can do this at 33,000 feet is because the patent doesn't teach you how to, is not right. And with the greatest respect, this illustrates the danger of trying to go back to what my learned friend has rightly accepted as a complex case and try to retrofit arguments which were not made before the judge because Dexcom got the wrong housing and Mr Vardy was interested in trying to do things other ways. And to take some cross-examination about Ethelfeld, when Ethelfeld expressly talks about using a foil or film or paper-like material, and then say, well, that's part of the CGK and you can use that for Claim 2, again, is ex post facto analysis, which wasn't said, it wasn't said in that way by Dexcom, and it will be wrong to start to try and go down that path now when the evidence just doesn't support it. So, my lords, we say, although we accept that the ground 5 is a subsidiary point really, and only comes into play, as my Lord Justice Arnold said, this morning, if we're wrong on ground 4, it does illustrate the difficulties of trying to re-argue points which weren't supported below. So that's ground 5. Then my learned friend took you on to grounds 3 and 4, and I'll deal with those together because the arguments about housing and manual insertion run together. Now, the first point that your lordships asked my learned friend about was, what is the right test here? Is there a difference between being wrong or a judgment being unsafe? And that was in the context of Lady Justice Fulk's argument and whether there's a causal link between the delay and the errors that might have appeared in the judgment. And I explained this morning why we suggest that there is a causal link between the delay and the errors because of the inevitable time it takes in between doing certain steps of the judgment, and therefore it makes it explainable why the judge forgot what the construction was when he got onto obviousness. And what Lady Justice Fulk made clear is that the distinction between an unsafe decision and one that's merely wrong is one where it's unfair to the appellant. We say in this case it would be unfair to the appellant to re-decide a case where there is an absence of evidence and you're asked to do it effectively afresh in this court without all the proper guide rails that a trial gives the judge. And the particular reason in this case why it would be unfair is plainly Abbott sought to argue for a broader construction of the claim before the judge in order to catch Dexcom's product. The judge, for good or ill, made the decision he did about construction, and he has trimmed Abbott's sales and trimmed the scope of these claims in such a way that he found that the Dexcom product did not infringe. Based on that construction, we say he should therefore have found the claim valid, but he has not done so because he has applied the wrong construction. And we say it is unfair to Abbott in those circumstances to where the court and the controller agrees and the court has been shown that the judge has fallen into error, and if there isn't material, as we say there is not, for this court to decide the point afresh because that material was before the judge in the way that a normal respondent's notice would be argued. We say it would be unfair for this court to impose a different decision. And at the end of my submission in a couple of minutes, I'll explain precisely why it would be unfair based on the findings of the judge. So, my lords, that takes us to the merits on grounds 3 and grounds 4. My learned friend fairly accepts that figure 33 is automatic. He says, well, you might be able to identify other parts of the housing in figure 33, and we discussed that this morning, but there's nothing to suggest that figure 33 is a manual embodiment. It's just not. The best that my learned friend can seek to show your lordships, and I appreciate he's doing his best to try to show what might be said. Firstly, was Heller paragraphs 205 to 207. Those are the passages which talk about the earlier embodiment. We'll just go to that. It's page 94 of the bundle. And this is talking about figure 26. And I did take your lordship to this morning. It's right. The beginning of paragraph 206 says the force applied to the insertion device, but remember that's the needle, that's the sharp, not the whole thing. The force applied to the insertion device and or the sensor may be applied manually or mechanically. But then they go on to talk about an insertion gun of figure 26, and that is only disclosed in automatic terms. So when my learned friend said earlier that this passage contemplates manual injection, that was the word he used, we respectfully disagree. What it explains is that the insertion device, the needle, may be applied manually, but when it comes to talking about injecting using figure 26, the guns, that's all automatic. So there is a distinction, an important distinction, and that's why I raised with your lordships earlier the way the judge tried to summarise this paragraph in the judgment, and did so making, with respect, the same errors that my learned friend has made by trying to do it in too compact a way where some of these points are elided. We say one has to be very careful, this is paragraph 209 of the judgment, one has to be very careful about exactly what 206 says, and all that is saying is that the needle may be applied manually, but as soon as you use figure 26, or indeed figure 33, as my learned friend accepts, you are doing it automatically. That's the first point. Then my learned friend sought to say, well, in Ethelfeld, the point was, can you go from manual to automatic? And the judge found it wasn't obvious, but it might be different going from automatic to manual, and therefore your lordships were entitled to make a different decision. First point is, why would it be any different? Why is it any less complex to remove material and to design a device which is the individual can push in and cause a stable, repeatable insertion together with an automatic retraction still there, than it is to do it the other way round? And with the greatest respect, my learned friend was just in the same problem-solving mode that the judge found Mr Vardy was in when he was dealing with Ethelfeld. He said, oh, you could try biasing the spring the other way up. That's the first time that's been suggested in 4 years of litigation. It's just not as simple as that, because you have to have the skilled person's approach, you have to be working from the document, and merely coming up with new problem-solving ideas many years later, even if it's done with the best of intention, is not the right way to determine a case such as this. He then also sought to say, well, maybe that none of this is of great importance. Maybe the difference between the way the patent refers to coupling or the automatic or manual is of no great importance. Well, it was of significant importance to Dexcom, and it was of significant importance to Abbott, seeking to have Dexcom's product found to be infringing, and it was significant importance to the judge, because the judge found that the only reason that Dexcom's product did not infringe was because it didn't have a manual insertion device. So, my lords, we say again.
I didn't understand that to be Mr. Baran's point. Thought the point was that for the skilled reader reading Heller, it wouldn't matter whether the insertion was manual or automatic. Not that it wasn't important in the litigation.
Right.
That's the way I understood it.
I understand. Well, as I explained this morning, there was evidence to say that the skilled person would want to have automatic over manual, and that was, and some of Mr Vardy's evidence saying it's advantageous explains that, and it all depends on what you had to do. It's the same problem as we have on Claim 5. It all depends what you have to do to turn something from one into the other to decide whether or not it's important or not. Because if it involves substantial changes which are going to take months to perfect, then it may well be important to the designer, and they would far rather not have to change anything in what is disclosed.
But one thing you'd have to ask is, what are the advantages of manual insertion over automatic insertion?
Yes, well, there's been evidence post the patent. There's nothing pre the patent. There's evidence post the patent about how clever, in fact, the Abbott system is, even though it's manual. There are several very clever parts of they're not part of this patent dispute, but there are other patents later to show explain how it works and how it allows repeatable insertion. But that's not part of the common general knowledge at the priority date here. And certainly the common general knowledge was that people wanted to avoid manual insertion at the time. So, and the judge pushed that. And the important point for those purposes is the point I made this morning on the table. None of the CGK devices were manual and then automatic. So not only was there no disclosure in Heller, as my learned friend has fairly accepted, of manual and automatic in those paragraphs we've looked at, but nor was the CGK, nor were the CGK devices manual and automatic. So whether you're trying to get to the claim through Heller alone, or whether you're trying to get it through Heller plus the CGK, you don't get a flag showing you where to go. And we say that would have been a very important point had the judge been asked to decide this point, or had he decided it based on his own construction. And it comes out again out of paragraph 336 of the judgment, where the judge is summarising Dexcom's case. And on Dexcom's case, where it was okay to have an automatic insertion, he says no substantial changes were required, which meant there was ample motivation for the skilled person to take Heller forward. If, on the other hand, substantial changes were required in order to turn Heller into a manual device, then the motivation may well have been very, very different. And that's something which my learned friend, because of the position he's in, he's just unable to address that. And the judge hasn't addressed it. There was no material before the judge to allow him to address it. And we say it would be therefore wrong for this court to assume it can understand the motivation of the skilled person and apply the correct test to Heller based on the construction of the claim that the judge arrived at. So, my lord, I'm not going to deal. My learned friend took you to parts of the patent which used coupled and operatively coupled in different ways. And obviously, that was all part of the parties' consideration at trial. And if they'd wished to put up forward arguments to assist on construction based on those passages, well, some of them they did, and others were not thought to be helpful enough to assist. In any event, that's not a point which is live before your lordships. And again, we say it would be quite wrong for your lordships to be tempted to think about a different construction based on something.
It's what led the judge to his conclusion that manual insertion was his claim.
Yes, and that is the construction we're dealing with. And so to go and say, well, maybe the judge shouldn't have come to that conclusion because operatively coupled and coupled mean the same thing, it is really not open to my learned friend to raise for the first time on his feet this afternoon. The final point my learned friend made was, he said, well, he pointed you to the reference where the judge said, and I confirmed this morning, that Mr Vardy, when he was talking about the patent, he said that he thought it was limited to manual insertion when he in that part of his evidence, and that's right. But when he
remind me of the evidence reference for that.
Yes, that I'm not sure we've looked. We may not have looked at that today, my lord. Let me just find. We may have to supply that to your lordships. Yes, I'm trying to work out whether the page on. I think it is there. So it's page tab 12, page 203.
Or the supplemental.
Of the supplemental, yes. So I think it's paragraph 9.44. and he says EP44 gives example of a manual insertion device, and I consider that coupled to the housing configured to move between refers to this type of insertion process, i.e. one in which the movement of the needle is driven by
Which
a
paragraph, Mr. Mitchell?
I mean, in 9.44,
4.4.
yes, the last two sentences of 9.44,
Yes.
and that was the passage that the judge stopped me cross-examining Mr Vardy on, which I explained earlier. So we don't dispute that was Mr Vardy's position in his first report when he was talking about the patent alone. But when he comes to talk about what it was obvious to do from Heller, he doesn't descend to the level of detail to suggest that actually what he's suggesting is obvious in terms of getting to a manual device. And that's the passage that I took you to this morning on page 118, where he talks about what it would be obvious to do. He first of all gives his evidence about what it would be obvious to do from Heller, and that's the evidence I showed you, explaining that he would get to an automatic device. Then he goes through the claims of the patent. He said he thought that was manual, and then in section 10 of his report, he's going through what I would do comparison of Heller and the claims, and that's where at 10.13 to 10.14 he is saying there, well, I think you're moving the needle from a position inside the housing to a position outside the housing. So there he is saying it's not in lockstep. It's not manual because it's an automatic device, which everyone's agreed, figure 33. So he is not saying there that the obvious thing to do from Heller is to get to a manual device. And although my learned friend said you don't need to have evidence saying that the ultimate step is obvious from the expert, because in the end that's a matter for the judge. What you do have to have is evidence that what the skilled person would do in a routine way from the prior art gets you into something which is covered by the claim. And that is not what these paragraphs 10.13 to 10.16 do, because all they do is establish, as Dexcom argued at trial, that the skilled person would make without invention something with an automatic insertion based on figures 32 and figures 33. And that's what you get from 10.13 and 10.14. And we also pointed out that he's identified the wrong housing here, which it may be why it's even more difficult to interpret. But he certainly has not suggested here that the skilled person has designed a manual insertion device. And so we say that this court, with the greatest respect, doesn't have the materials to make a decision that the judge's construction was obvious, because there is simply no evidence to support that. And Heller, the disclosure of Heller, points strongly towards an automatic device, and there is no disclosure of manual insertion and automatic retraction in Heller. And to design something like that would be a very substantial departure from Heller. And that's where we say those passages of the judgment, which I relied on this morning, are key, because had the judge been asked to decide whether or not manual insertion and automatic retraction was inventive or not, we say that he would have had the same considerations as he had for the other factors which were said to be, by Abbott, obvious over this common general knowledge, where he said there was weight to a number of the considerations which Abbott put before him on hindsight, and Mr Vardy's step of going to problem-solving mode. And so if I just give you the references, we don't need to look at any of them. it's the judgment, paragraphs 139 to 144, where the judge explains the benefits of the patent, and he says, that's where he expressly says, well, Abbott relied on these, they may be more relevant to obviousness over the common general knowledge. But of course, effectively, if Heller doesn't disclose manual and automatic, you are having to rely on a combination of Heller and the common general knowledge to try and get this argument off the ground. And we say that's precisely where all these pointers in the other direction come into play. So there's 139 to 144 about the disclosure of the patent and its impact compared to the common general knowledge. There's 267 to 297 about hindsight, and in particular paragraph 295 about hindsight, which is where the judge cites the plastic springs and levers or needles passage from Mr Vardy, and he gives that weight when he returns to it later. Then there's 298 to 318, which are the facts, the difference between the facts over the CGK, obviously it's facts over, particularly over the CGK. Then there's the Ethelfeld passages 330 to 334, and particularly the judge's conclusion in 334 that without Dexcom having shown precisely what the skilled person would do from Ethelfeld to get into the claims, he was going to reject the finding of obviousness over Ethelfeld. Then there's Heller, the final 5 paragraphs on Heller at 388 onwards. Firstly, where he says, well, I'm going to dismiss most of the Abbott's concerns over Heller because Heller is not common general knowledge, and Heller tells you how to implement a specific device. That may be right for the finding the judge reached on Dexcom's construction, including automatic, but as soon as you go to the judge's construction, manual and automatic, Heller has not told you how to implement that. And the experts did not say that that was obvious. Mr Vardy didn't give a design which he said would give this. He didn't do it in his reports, didn't do it in his oral evidence. And so...
well, I thought you disavowed the suggestion that Mr Vardy had to say in terms, it is obvious.
He doesn't have to say...
Your point was that he had to explain what you had to do.
The ultimate question of, is it obvious, or is it and routine, or is it inventive? That is for the judge.
Yes.
And that there are a number of judgments saying that ultimately what the expert says is obvious is not really the key. It's the reasons underlying it. But what the expert has to do, he or she has to get into a position where he has said he has arrived at something falling within the claim. And that's Mr Vardy never did that in this case.
Yes, well, that's your real point, isn't
Yes,
it? He didn't explain how he would get there.
Yes, and so you can't try and use arguments about other steps to then say, well, this extra step, which no one's dealt with, must also be obvious too, because it's similar or it's the same. Who knows what one could try to say. And that, so because Heller doesn't teach you how to implement manual insertion and automatic retraction, Abbott's criticisms of hindsight do apply. The same for 389. This is, again, Mr Vardy was acquitted of hindsight because he said this is what you would do, but it's no good if he said what you would do if that doesn't fall within the claim, as the judge found it, as he didn't. 390 is where he returns back to acknowledging the strength of the point we made about just saying it's all plastics and springs and needles. That's very dangerous with hindsight in these difficult mechanical patent cases. And then finally in 391, it certainly wasn't inevitable that you would get from figure 32 and 33 to something with manual insertion, automatic retraction. On the contrary, we say nobody suggested that's what you do. Heller didn't suggest it. The common general knowledge didn't support it because none of the common general knowledge devices had that, and none of the witnesses said it at trial either. So for all those reasons, we say that if you take the bits of the judgment which you should accept because they're not challenged and there's no basis for challenging them, and you then apply those bits of the judgment to what my learned friend is asking you to do on the respondent's notice, and I accept he's trying to put forward everything he can to your lordships, but if you apply the judge's reasoning and judge's thinking to this and take into account the absolute absence of evidence from the experts, the absence of disclosure in Heller, the absence of material in the common general knowledge, the only safe conclusion your lordship should reach today is that you should reverse the judgment. The patent should be put back on the register, and if there has to be an argument another day about a different approach, that is for another party to take. Unless I can assist you any further, those are my submissions.
Thank you very much, Mr Mitchison.
Sorry, my learned friend says, could I hand up Coflexip? And I'm happy to do that. So your lordship.
Coflexip?
Yes, yes. Do you want to say anything about it?
Only one sentence.
Okay. He wants me to hand it up, and then he wants to. You can make a comment, which of course is. Just one other point, my lord just asked, was there anything in closing that changed the approach to construction? Yes, and we've looked at that over lunch, and it's all consistent with what we found in the written documents.
Very good, thank you.
Thank you. Well, it will not surprise you to learn that we will reserve our judgment.
My lord, I was going to make one sentence about this Coflexip case, which my learned friend didn't raise in his opening, and I made no criticism for it. The point that my learned friend was talking about earlier on comes up right at the end of Lord Justice Chadwick's judgment, paragraph 26 and so on. There are two things to note about this judgment that make it rather different. First is that in that case, the judge below had found the patent to be valid, and the appellant was trying to suggest it was invalid. So what was happening there was that the remittal was sought by a private party, and what Lord Justice Chadwick says at the end is that the court shouldn't allow a private party to use the public system in a way that could be wasteful of public resources to advance its private interests. Of course, that's not how things would be shaking out in this case, were you to consider that you needed to remit something. So it doesn't really read on, which leads to my second related point, which is that my learned friend made several points about fairness to Abbott if you were to take a course such as this or to redecide the case. Of course, all I would say is that the interests of the public weigh into that balance also in not having an invalid patent on the register. This is not a one-sided consideration. Aside from that, I have no further points to make.
Mr Mitchison, do you want to say anything about Coflexip? Right. Well, as I said, we will reserve our judgment. You will get drafts in the usual way. Don't be disappointed if they're not under the Christmas tree. The receipt of the draft will be your opportunity to correct our spelling and grammar, minor typographical errors and so forth, but not to introduce new points. We would hope that in the light of the draft you will be able to agree an order disposing of the appeal. If you can't agree a form of order, please make short written submissions and we will make the order that we consider to be appropriate. I should have said the draft judgment will come with a fierce embargo, which means what it says, so it can only be distributed to those on the distribution lists. And when the judgment is eventually handed down, it will be done electronically and by release to the National Archives, so there will be no need for further attendance. Thank you all very much.
Court rise and able.